in India and globally. As the advent of the Industrial Revolution, the dispute has also become inevitable, which in consequence led to arbitration as the most preferred platform for quick resolution of disputes. Now, with extreme honor, I would like to introduce you all to the speaker of this session, Mr. Vikas Mahindra, partner at Keystone Partners and also the co-founder of Center for Online Resolution of Disputes. Sir is dual qualified. He is admitted as an advocate in India and a solicitor in England and Wales. Sir is a specialist arbitration practitioner and is member of Chartered Institute of Arbitration and has experience of handling investment treaties, commercial arbitrations, both ad hoc and institutional, in India, Southeast Asia, Central America, Africa, Europe, and United Kingdom conducted under UNICITRAL, ICC, SIAC, LCIA, and ICA rules of arbitration and Indian Arbitration and Conciliation Act. Before joining Keystone Partners, he worked for 6 years in arbitration and litigation department in Herbert Smith Freehills, London, Paris, and Singapore offices. Sir is a part of list of arbitrators maintained by HKIAC and Reserve Panel of Arbitrators in SIAC. He is also regularly invited to speak at conferences organized by arbitration institutions such as ICC, LCIA, SIAC, and CIR, and provides training sessions to public and private sector undertakings. He recently assisted the high-level committee constituted by the Government of India to review institutionalization of arbitration in India. Just a bit of notice I would like to bring up to you. If you have any questions during the session, please type them into the chat box. We will be keeping tab on questions and will be answered after 35 minutes of your sessions. Now, without wasting any moment, I invite Mr. Vikas Mahindra to share his valuable knowledge on the matter. Over to you, sir.
Thank you for the very kind introduction, Chaitanya. Hi, everyone. It's a real pleasure to meet you. I mean, there's both pros and cons to doing things virtually. The pro obviously is, here I'm sitting in Bangalore and probably interacting with all of you sitting across the country. The con, of course, is that, the element of interpersonal interaction, which would have been invaluable, is missing. But let's see what we can do in this virtual medium and make the best out of it. What I will be covering in the next 40 minutes is some background to what alternative dispute resolution is. So while I will be touching upon arbitration, I will be looking at alternative dispute resolution a little bit more broadly. And the idea is to set the stage to understand exactly what it is that you can get out of alternative dispute resolution, and then maybe evaluate what arbitration is, what it is providing, what it is not providing, so that you have an informed decision as to what are the various options and what to choose in a particular scenario. Let me first start with a dispute. Now, what is a dispute? A dispute is any disagreement between parties. If a brother and a sister are unable to agree on who gets to go ride on their father's motorcycle first, that's a dispute. You need to resolve it because, maybe that there's only seat for one. You cannot have both of them go through. So you'll have to find some resolution to even simple elements like that. The same element of a disagreement between parties, i.e., one party wants something, the other party wants something else, is the crux of any dispute. That could be a multi-billion-dollar dispute between the biggest powerhouses in the world. Maybe they're talking about the construction of the biggest, airport or power plant, whatever. But eventually, it boils down to the same common disagreement between parties on some or the other matters. There are various ways and means of resolving a dispute, and we need to bear in mind that one or the other mode of dispute resolution is not suitable for everything. One cannot say that arbitration is the best mode of dispute resolution for all disputes. And that's something that we need to bear in mind as practicing lawyers. And even if you are arbitration specialists, you need to constantly keep that at the back of your mind to say, is this really a fit case for arbitration? Do I need to push them through this? Or is there another way to resolve it? Take the same example I gave you. If there is a disagreement between a brother and a sister, you don't take them to arbitration. You don't make them submit statement of claim, defense, witness statements, cross-examine them. What you do is you sit them down and try and understand what their needs are. And maybe their father or the mother acts as a little bit of an in-between to try and find out what exactly is the issue and helps resolve that. And it is necessary to have these informal dispute resolution mechanisms, because otherwise life as we know it cannot go ahead. Because disputes are encountered every step of the way. For instance, you could be going on a car in the middle of the street, you might have scraped someone. Now, if you were to take every single instance of that, take them to court, take them to arbitration, do this entire elaborate mechanism of dispute resolution before you arrive at a solution that I need to pay him 500 rupees, then the transaction cost of this entire thing is far greater than the actual loss cost. Now, what is transaction cost? If there are people who have done economics, you might understand it a little better. But the transaction cost is the cost of achieving a result. So, for instance, if in the dispute, I mean, I'm talking about where the person's car is scratched, the transaction cost will involve the time spent in trying to resolve that dispute. Maybe the mental effort and agony in, if it takes 2 months to try and resolve that dispute, that time, the effort, the strain, anything else you could have done, all of that is, has to be let go because you're trying to resolve these disputes. All of those are transaction costs. The higher the transaction cost, the less likely people want to resolve a dispute. Because obviously, if the cost of resolving is far greater than what I'm ultimately going to end, I'm not going to do it. I'll say, I just let it go. That is why it is important for us to tailor the transaction cost to the dispute. And that is where the choice of dispute resolution mechanism becomes crucial. One needs to understand what is the cost of resolution, and not cost simply in terms of money, cost in terms of time, cost in terms of effort, cost in terms of what else you could have done in that. So it's not simply an actual how much money is going out for you, but if I wasn't doing it, was I going to be doing something else? Could I have spent my time and money better? You need to take all of these factors into account while deciding how you want to resolve a particular dispute. And it may very well be that in a lot of cases, no mode of dispute resolution is cost effective enough, so you just let it go. So sometimes dispute go unresolved, and that from a pure economics perspective is perfectly acceptable. And that's something that we need to understand and we need to evaluate in each circumstance. Let me give you concrete examples as we go through. But before that, some brief overview of the more popular modes of dispute resolution. And I say more popular because there's never going to be an exhaustive list of dispute resolution mechanisms. It's always going to be tailored. But what are the most popular ones? The first, most basic one that people use is negotiation. What is negotiation? Negotiation is simply two or more people having a conversation with each other, trying to put forth their point of view and trying to convince the counterparty that they're either entitled to something or that the counterparty should not get something. In negotiation, the only actors involved are the parties to the dispute. So in the car situation, it's the driver of one car, it is the driver of the other car, they have that conversation. They maybe get out, they have a conversation and say, listen, you were overtaking me from the wrong side, you scratched my window, it's probably going to cost me about 5,000 rupees to replace it, so why don't you give me that? If the other party agrees, and there's no one else involved, there's just these two people, assume it's an empty highway, there's absolutely no one else involved, that is negotiation. And that's maybe a very simple form of negotiation, but that's the basic concept. Negotiation is by far the most prevalent form of dispute resolution. Every single dispute starts off in an attempt to dispute resolution through negotiation. So it's important that you understand that that's the first step. No one goes through the very formal ways of it without at least trying to resolve it with the other side. There may be some instances where maybe you want to drag them to court, you want to drag them to a police station. That's different. But in any normal kind of a situation, negotiation is usually how you try and resolve these disputes. And that applies to a number of disputes. It may be a family dispute, for instance. If there's a fight between a husband and a wife, you're not doing your household chores, you're not cooking well, whatever, right? A whole myriad of those kind of disagreements or disputes are resolved on an everyday basis with simply talking. And that channel of communication, the channel of correspondence between the parties can help facilitate that. But sometimes that channel may not be available, or that channel might have been broken beyond repair, or for some extraneous circumstances, you might not be able to avail that channel. Take, for instance, if language is a barrier. I may not understand what you say. You go to a foreign country, same thing, you've scratched someone else's car, you don't speak their tongue, they don't speak your tongue. You can't, as parties between each other, resolve that dispute. So what you need to do is you need to try and find some other person who will come and help that dispute. being resolved. And that is where you move to the next more popular way of dispute resolution, which is mediation. Mediation, again, note, is a spectrum. What do I mean? In mediation, apart from the two parties to the dispute, there is one more individual, or maybe set of individuals. It may be 3 or 4 or 5, 10, whatever. But there is this other people who try and help the parties reach a resolution. So, for instance, in the example where I said, when someone scratched your car in a foreign country where you don't know a language, maybe an interpreter acts as a bit of a mediator, where there the role of the mediator is very, very minimal, where the mediator is simply translating one person's speech to the other, but he's facilitating resolution. That's the simplest form. In other cases, it might be in the other end of the spectrum, where the mediator takes an active role to try and facilitate mediation. How is that happening? That usually happens when the line of communication or correspondence between the parties is broken. Take, for instance, a case, let's say a husband and wife are having a problem. They've probably had a problem for 10 years' time. They're not in a position where they're even capable of seeing face to face with each other. The minute they start being face to face with each other, they fight, they yell, they scream. So no communication can happen between the parties. In that situation, it's extremely crucial for there to be a third party. That third party could be, I don't know, your mother, your father, some common elder that parties respect, maybe the kid, maybe the child in the equation, which says, okay, you know what, let me communicate between you two. And you've seen the classic example in all these movies where they say, instead of speaking to the husband, they speak to the kid. Husband's in the same room, but they tell the kid what they want to tell the husband. But there the kid is playing the role of a communication channel, and a mediator can play that role and help bridge that communication gap between the parties. There, the role of the mediator is obviously a little bit higher, because you're not only trying to translate what one person is saying, but you're actually trying to get people to open up, get people to tell you what their point of view is, etc., and then try and resolve the disputes. In both negotiation and mediation, we can take an entire course on it, so I can't give you an entire overview of it, but just as a summary, the way a party negotiates or a way a party mediates, there are multiple options. There are various different strategies of doing a negotiation and a mediation. Some of the strategies you may have heard of. You may have heard the expression good cop, bad cop. This is usually a situation where, for instance, trying to negotiate with the party, one person just comes across as being super aggressive and saying, especially in a police interrogation kind of situation, one person comes in and says, I'm going to put you in jail, I'm going to get you, death penalties, I'm going to threaten you, be all of those things. And then after a while, the other guy comes in and says, you know what, do you really want to go down that path? I will convince him. I'll make sure that that doesn't happen. Why don't you just help me out a little bit? So you soften the strategy. So that's why you play good cop, bad cop. The other way of trying to negotiate is where you go on pure numbers. So where you will say, I start with 100, you start with 50, we'll split it down the middle, 75. That's just one way of doing negotiation. Another way of doing negotiation, and a lot of people find this to be the more effective way of doing negotiation, is what's called interest-based negotiation, which is, if people have a dispute, you try and understand why they're fighting, instead of starting with the question of what you're fighting about. Why are you fighting? And the classic example given, and this is very often repeated, but makes the point effectively, is the case of the orange. Now, two kids are fighting about an orange, and the mother is then put in a position to say what to do. I can't give the orange to one or the other person. Both of them want it. So how do I address that issue? If you talk about a simple numerical economic kind of split, what a person might have done is they might have cut the orange in half, given one half to each of the parties. But there, that might not necessarily be effective or the most efficacious way of resolving disputes. What you would do in an interest-based negotiation is you try and find out, why do you need the orange? And one person said, I want the orange because I want to eat the orange. The other one said, I want the orange because I want the peel to make orange rind. I want it for my cake. Now there, the mother realizes that instead of cutting the orange in half, it is easy to peel the orange, give the peel to one person, give the orange to the other, and then both of their interests are met. So this is a situation, what you talk about interest-based negotiation. So you try and understand why people are fighting about. So that's another way of negotiating. again, like I said, there's a whole range of ways of negotiation, but just be aware that negotiation, again, is not simply one pigeonhole where you can put things into. There is a lot of variety even within negotiation. And that carries forward to mediation as well. The role of the mediator, like I said, could be one of a translator. Two, on the other end of the spectrum, sometimes a mediator, or there the mediator becomes a bit like a conciliator. A mediator may evaluate the situation. So they might have heard both the parties and say, what, based on what you're saying, I think there is some merit in what X is saying. What do you feel by? So there it goes from simply communicating what one party is saying to the other to actually evaluating what that party is saying and giving a little bit of an opinion of what I feel is fair in those circumstances. That's the other end of mediation, which becomes conciliation. So you start with negotiation where it's just the two parties, no one else. There's a whole variety of negotiation strategies. Then you move into mediation where there is a third party involved. And even in that, like I said, it's a spectrum. You start with one end of the spectrum where it's simply a communication channel. Then you go into somewhere in the middle of the spectrum where you're trying to interpret what people are saying, distill out those elements, and then communicate to the other party. Maybe in that same middle of the spectrum, you're trying to get the party to open up, get the party to speak. So you're making an active role to actually encourage settlement. And on the other end of that spectrum will be where you're not only hearing the parties, but you're also communicating your opinion on matters and say, in my view, ABCD is possible. In my view, this should be done. That's the range of mediation. Now, in the end of the spectrum where I'm talking about some amount of evaluation, there's a number of different existing mechanisms which already operate. Conciliation is one of them. So, and I know this has been only 5-6 minutes into what I've been talking, and I've already used a number of expressions which might be a little difficult to comprehend, but bear with me. I will come back to each of them in a little bit more detail. I'll explain the nuances, but just an overview for now. So conciliation is one of them. Lok adalats are another example where it's a facilitated mediation where the mediator is playing a little bit more of an active role, a little bit more of an evaluator role in practice, maybe not in theory, but in practice, that's what they do. So there's a number of existing options which are called by different names, but all of which are essentially mediation. Now, the quintessential feature of both negotiation and mediation is that the parties are the ultimate decision makers. In a negotiation, if I don't agree, I've scratched your car, you say 5,000 rupees, I say absolutely not, it's probably worth 100 rupees. There's simply no agreement between us as to what the eventual value of our dispute is and what the outcome is. And if I'm unable to agree on an outcome with you, there is no resolution. So this is a situation where there is a dispute resolution mechanism, but no resolution. It's possible. So it's entirely possible that you have a dispute, you try to resolve it, but there is no resolution. And that usually is, it's completely to be expected in something like a negotiation, where resolution is only based on consent of the parties. So unless the party consents, there is no resolution. Similar is mediation. Even in mediation, unless the parties consent, there is no resolution. So there might be a third party in the room. The third party might be trying to communicate, might be trying to evaluate, might be trying to get all of your interests out on the table. But that third person has no authority to decide your dispute. That third person is simply in the room to facilitate conversation. Therefore, even in a mediation, unless the parties agree, there is no resolution. If the parties agree, of course, there's resolution, but unless they agree, there is no resolution. That is equally true of the end of the mediation spectrum where the mediator is expressing an opinion. That is conciliation and lok adalats. Even in a conciliation, unless the parties agree, there is no resolution. Even in a lok adalat, even if the power dynamics are a little bit different, and I'll come to that slightly later. But even there, unless you, the party, agree, the judge sitting as the Lok Adalat member cannot force you to agree to a settlement. So if you say, no, this is not good enough for me, that's not good enough for you. You can walk out of this entire process if you're not satisfied. That's why party consent is primary. So we've talked about negotiation, we've talked a bit about mediation, conciliation, maybe lok adalat. Let's move a little bit more along the spectrum. The next creature that falls is arbitration. And that's probably what we'll be discussing for the next couple of days. What are the commonalities of arbitration with negotiation and mediation? It's the parties who are involved. So to that extent, it's a dispute, so that's common. Unlike negotiation, but a bit like mediation, there is another party in the room called the arbitrator. So that arbitrator is there to help the parties resolve a dispute. So to that extent, it's similar to mediation. But that's where the similarity ends. Arbitration, unlike mediation, is where this third party has the right, has been given the power to decide the dispute for you. So unlike in negotiation and mediation, where I told you that unless the parties agree, there is no resolution, that is not the case with arbitration. You may not agree, you may never reach an agreement point, but the arbitrator can force a decision in that matter. They can decide the dispute for you. That arbitrator is empowered both by the parties and by law to decide the dispute for you. And it's important to remember that there are both of these elements, that the arbitrator is authorized by the parties and authorized by law to decide the dispute. In arbitration, there is an element of informality. And that is another similarity with negotiation and mediation. So unlike, for instance, in a negotiation and a mediation, you don't necessarily have to go to court. And although there is court-annexed mediation centers, even those are not inside a courtroom. You are very much in an informal situation where you're sitting across a table with each other and trying to resolve a dispute. So there is an element of informality. Unlike, let's say, a court where Judge Saab is sitting high up on the pedestal, you are submitting to their lords or your honor or your excellencies or whatever you call it these days. But there is an element of hierarchy where the decision maker is somehow above you. But in mediation and negotiation, people are almost on the same footing. That even literally, if you look at a mediation room or a negotiation room where you're sitting in the room, people are sitting on the same level. People are sitting across the same table. So there is an element of informality, and there is a lot less procedural rigor as compared to court. And I'll come to these elements a little bit later, but just to say that element of informality, which is there in negotiation and mediation, carries through to arbitration as well. Arbitration is little less informal. I mean, there is elements of formality there also, and I'll come to that. But by and large, it's more informal than courts. So it's, again, everything we're talking about is a spectrum. And in that spectrum in arbitration, you lean a little bit more in terms of informality than towards formality. That's on arbitration. And the next limb of the same journey of dispute resolution would be courts. Courts is where you would litigate. Litigation is, under law, you have the right to approach the court if you have any dispute. You ask the court for the relief. The court hears both parties and passes a judgment. And that judgment finally resolves matters. It settles the dispute. So even if in that extent, it's very similar to arbitration, where irrespective of the agreement of the parties, the court will decide the dispute for you. Okay. If I'm sorry, if my voice is cracking, please let me know. It looks like there's some instability in my internet, but I'll continue. So that's the journey, right? And that's the sort of 10-minute overview of the various dispute resolution mechanisms. Now let's do a little bit more of a deep dive into some of these elements. And let's do it by way of compare and contrast. So let's talk about for instance, negotiation versus mediation to start with, and then we'll go with sets of things. And then by the end of it, I'll probably focus on arbitration a little bit more. How is negotiation different from mediation? Already we've discussed that there is a third party in the room who's not there in negotiation. Now, mediation and negotiation are similar in that both of them end in a settlement if the parties agree, right? Negotiation, if it ends in a settlement, is reduced into a contract. It is reduced into what is called a settlement agreement. which means both the parties say, yes, I agree, this is the way to resolve the dispute. And they reduce those terms into a formal contract. They may not. For instance, in the context of the car scratching event, you don't really have a formal contract, but there what you have what's called the gentleman's handshake or an informal contract, where the two parties agree with each other as to what the consequence of all of those things needs to be. So while there is no written agreement, where there is an oral agreement in that sense of the term. In a more civil commercial kind of a situation where you're talking about slightly more sophisticated parties, invariably when there is a negotiation and the negotiation ends a dispute, you reduce it into writing. It's extremely useful to reduce it into writing because it avoids ambiguity. As you can all imagine, if both parties agree and it's simply an oral agreement, imagine trying to think of every single word that was said in that oral agreement 10 years down the line. If, for instance, somehow that negotiation unravels, it's very difficult, and it's very difficult to prove exactly what was said. So it becomes a question of he said, she said kind of a situation, and you don't know exactly what happened. So it is always advisable when there is a negotiation that at the end of the process, you reduce the terms into writing so that there is no ambiguity, and that results in a negotiated settlement. Similarly, like in negotiation, a mediation also is ended by reducing the terms into a settlement agreement. So the parties agree, they enter into the mediation, they complete their dispute, then they put it into the form of a settlement agreement, and that's the end of the dispute. Although both negotiation and mediation end in a settlement agreement, if the parties agree and if there is successful resolution, there is still some distinction between negotiation and mediation. In a number of countries, a mediation settlement agreement is enforceable in law, unlike a negotiated agreement. What does that mean? I'll take the example of Singapore. In Singapore, there recently, you may have heard in the news, there's a Singapore Mediation Convention. It's an international convention where a number of countries came together and they said, we want to encourage mediation. So let's make it enforceable. So that, after mediation, once you've agreed to everything, you then don't resile on your promise. You then go and say, oh, actually, I didn't say this, or even though I've said it, too bad, and the party is forced to go to court to enforce the mediation agreement. That shouldn't be the case. So what they've done is they've now made it automatically enforceable, like an arbitration. And I'll come to arbitration a little bit later, but just to point out that in some countries, there is a distinction between a settlement agreement entered into via a negotiation and entered into via a mediation. A mediation agreement can be automatically enforced. Now, why do I say some countries? Because that's the truth. It's not every country. And importantly, India is not yet there. As of today, India is mooting a mediation bill. There is a debate, there is a discussion happening. It's been tabled before the parliament, and there is a lot of hope that within the next year or two, an act. There's a lot of support for it from the Supreme Court. There's a lot of support for it from the parliament, but it's not yet there. Whereas there are other countries where it is already there. But there is, at least to my knowledge, and it seems unlikely, which makes a negotiated agreement enforceable in law. Negotiable agreement is still enforceable. What do I mean? It means that there is a contract, and like any contract, you can enforce it, which means you can take the contract to court or whatever that dispute resolution mechanism is, and you can say, this is the terms of the contract. I will prove that these are the terms of the contract. Please enforce it. So that's still possible, but you need to go file a separate suit for that. Whereas if you make it automatically enforceable, then you short circuit the process. So instead of going through filing a suit and then coming to an enforcement petition, you directly go to an enforcement petition and you enforce it. So you short circuit the process of enforcement. So while a negotiated agreement is also enforceable, please don't assume negotiated agreement is not enforceable, but it's a more complex process of enforcement because you still have to go to court, you still have to go to arbitration to enforce it. Whereas a mediation agreement in those countries where mediation agreement is automatically enforceable can be directly enforced by way of an enforcement petition. So there is, again, even though there's the same settlement agreement, there's some distinction in treatment. Now, while I have said that a mediation agreement is not enforceable in India, a conciliation award is enforceable in India. What is a conciliation award? I told you a conciliation is one end of a spectrum in mediation, right? So what that means is that not every kind of mediation settlement agreement in India is enforceable. It is only that extreme end where it goes to conciliation that it is enforceable. What is conciliation? How is it distinct from mediation? You'll remember from about 10 minutes ago. Conciliation is where the mediator can even make a little bit of an evaluation. So they help the parties not only by listening to them, but by also trying to convey some sort of opinion. So if a conciliator is appointed, then there is the Arbitration and Conciliation Act 1996, which makes a settlement award that has been executed by way of a conciliation enforceable in a court of law. So the entire spectrum of mediation is not unenforceable. It's only the spectrum which does not include conciliation. If it is conciliation, it's enforceable. Similarly, Lok Adalat. I've told you Lok Adalat is also a little bit like a mediation, right? Even that is enforceable. So while you have one large chunk of mediation which is not enforceable, there is a small chunk of conciliation and Lok Adalat which is enforceable. Again, that's a distinction between negotiation and mediation. I hope that's clear. For a negotiation, parties are usually at their own liberty to decide whether or not to negotiate. Whereas in mediation, you may have a legal obligation to mediate. Now, what does that mean? Imagine a situation where you've entered into a contract. In the contract, you say, if a dispute arises, I will negotiate. That's one contract. That's contract number one. And if I can't negotiate, then I'll go to court. Let's say that's one contract. The second contract says, I have entered into this contract. If there is a dispute arising out of this contract, I will mediate this dispute under XYZ rules. I mean, you don't have to have rules, but it's possible to have a set of rules. And let's say I've chosen that. I've said I'll mediate under camp rules of mediation. And if that doesn't resolve, then I'll go to court. Now, there are two contracts, contract one and contract number two. In contract one, the contract says that first you will try and negotiate the dispute. In law, it is still unclear whether that simple language is enforceable. What does that mean? If tomorrow a dispute arises and you don't negotiate, you don't even send me a notice saying, yes, I have a dispute with you, but you directly go to court. Can the court say, no, I'm not going to entertain you. Please go back to negotiation. That is when negotiation will become legally enforceable. Similarly, if there is a mediation, a mandatory mediation, and a party skips that step and comes to court, what will the court do? Will the court say, no, I'm not going to entertain it, please go back to mediation? That's the question we're asking. And the answer is, in India, unless the negotiation clause is specific enough and it's deterministic enough, which means there must be some amount of certainty to it. It should not be an agreement to agree. Because a simple agreement which says I shall negotiate is an agreement to agree, because there is no structure to the process. There is no, I'm not saying, okay, I will negotiate, I'll try and negotiate for 30 days. There is nothing which says that the negotiation will happen between the chief operating officers of the two companies. None of that. If none of that is there, then it's simply an agreement to agree. And that is not enforceable. So in negotiation, there is a whole host of clauses which are not enforceable in law, which means you cannot force a party into negotiation. But if you've agreed to mediation, out of 100 clauses which have a mandatory mediation, about 90% of them will be enforceable. Why do I say 90%? Because the remainder 10% might still be very vague and ambiguous. They might simply say, I will mediate, without identifying who the mediator is going to be, how the mediation is going to be conducted, how long the mediation is going to conduct, all of those things. So it may be that that mediation clause is not certain enough. So it is entirely possible that mediation agreements are not enforceable, but by and large, if there is an agreement which says mandatory mediation, it is enforceable. And by and large, if there is an agreement which says I shall negotiate, it's usually not enforceable. So that's again another distinction between negotiation and mediation. So for instance, if you want to reduce transaction costs, because you remember what I talked about at the starting, right? The transaction cost, the cost of dispute resolution of an arbitration and litigation is very high, because you have to spend money on the judge, on court fees, on the arbitrator's fees, on your lawyer's fees, and you probably have to enforce it. So there's a lot of cost involved. If you want to avoid that cost and say, before going into any of these, let me try negotiation or mediation, then please ensure that there is an enforceable clause, because then otherwise You just put in a clause which says, I'll try and negotiate, you may not be enforced. That's a distinction between negotiation and mediation. I'm conscious I'm running out of time, so I'll try and speed up a little bit more. Next, we'll move to mediation and arbitration. We've already talked about the distinctions, the most significant being that in an arbitration, there is a final and binding decision which automatically comes and which is enforceable irrespective of the choice of the parties. Whereas in mediation, it's still very much the choice of the parties. Second, enforceability. Like I said, in a number of countries, mediation agreements are still not enforceable. Singapore is a rare exception. But arbitration, on the other hand, is the exact opposite. Arbitration is almost always enforceable because of what's called the New York Convention. And I'm sure, Arush, when he's talking about the various laws that govern arbitration, will cover that element in a little bit more detail. So enforceability wise, arbitration is significantly superior to mediation. But in some senses, arbitration is not better than mediation. How? Mediation can give you a holistic solution. So for instance, if I have a dispute between you and I, so I'm a supplier, you're a purchaser. If there is a dispute, the arbitrator will only look at the contract and decide who is right, who is wrong. Whereas a mediator can look beyond the contract. So the mediator can say, okay, I understand you have a dispute on this particular transaction, but can you, for instance, enter into 2-3 other contracts, give them further purchase orders so that any potential loss on this particular transaction is offset by something else. There, you're not focusing on the contract. You're looking much more beyond. And you're saying, I will expand the pie and then split it between the parties. It's possible to do in mediation. It's possible to do in negotiation, where you need not restrict yourself to the actual core of the dispute. You can go well beyond, and that the arbitrator cannot do. Very recently, I had a case where there were a number of criminal cases also that were filed. Now, in an arbitration, you can't deal with that. And that's a limitation of arbitration, because there are certain disputes which are called arbitrable. And what do you mean arbitrable disputes? Meaning only civil cases of a commercial nature are arbitrable. But any other kind of case is not arbitrable. So a family dispute, not arbitrable. You cannot submit to arbitration. Criminal case, you cannot submit it to arbitration. Wills, testamentary disputes, insolvency, a lot of things are not capable of being resolved by arbitration. But a number of things can be resolved by mediation. So in that sense, mediation as a mechanism can provide a solution to a significantly wider set of disputes as compared to arbitration. Then very quickly, arbitration and litigation, the distinction between the two of them. Litigation, like I said, is very, very formal. You have the Code of Civil Procedure, you have the Evidence Act, you have to go to the High Court or the trial court or wherever it is that you need to resolve the dispute. So there's a number of very rigid steps that you need to follow. You don't have the choice of the decision maker. So for instance, if I have a dispute about a really complex nuclear power plant, about which only maybe a select 10-20 people in the world have knowledge of understanding that dispute, I can, in arbitration, select that person to be the arbitrator. So that person can understand and resolve the dispute. So there's a little bit of expertise I can bring. Whereas if I go to court and litigation, I don't have the ability to choose my decision maker. So that might be another limitation. On the other hand, in court, I have the option of an appeal. So if the first instance judge gets it wrong, I can go to the High Court or wherever the appellate provision is to try and rectify it. Whereas in arbitration, I don't have the ability to appeal the decision. It's one decision and that's the end of the matter. Cost-wise, again, it depends a lot on how an arbitration is run. An arbitration can be extremely cost-effective because of the procedural flexibility. I can say no oral hearings. I can say documents only arbitration. I can say even if hearings are conducted, let's do it on an online medium. Let's not assemble in a place. Whereas in litigation, you don't have that many options. So it is very rigid. It therefore is possible that in litigation, the costs are high. But the way the arbitration is practiced currently, a lot of these retired judges charge an exorbitant amount as fees. So arbitration, the way it's currently practiced, not as theory, but as it's currently practiced, is extremely expensive. Arbitration can be time effective also, especially in India, by the new arbitration enactment makes it time bound. So it says 12 plus 6 months for the resolution of a dispute. So you have some certainty as to how much time it's going to take. Whereas in court, if you go to any lawyer and they ask them, if I file a suit in the civil suit, how long is it going to take? They'll say something in the region of 5 to 6 years. If you're in Bombay, 10 to 12 years. So it is a significant amount of time that litigation takes. So there is a huge time advantage to it. And obviously, appeal is another mechanism. So while on one hand, appeal is good, on the other hand, appeal also means another 10, 12 years added to your litigation journey. So all of those things mean that there are distinctions between arbitration and litigation, which will make it more appropriate to choose arbitration in some cases and more appropriate to choose litigation in some other cases. Also, because of this whole question of arbitrability, meaning there's only certain kinds of disputes that you can resolve by arbitration, it is entirely possible that you can't even submit it to arbitration. So you have no choice but to go to court. That's a whirlwind tour of this. I just want to spend one more minute on ODR because I understand there was also a question on it. ODR is online dispute resolution. Online dispute resolution is not a different beast. So in that spectrum I'm talking about, where negotiation, mediation, conciliation, arbitration, litigation, ODR doesn't feature in that spectrum. ODR sits on top. ODR can equally apply to litigation. It can equally apply to negotiation. ODR simply means, or online dispute resolution simply means, you're using technology to facilitate dispute resolution. So for instance, it can be from very simple things like where you file a case. Instead of filing it physically, you can upload it onto a particular platform. How do you serve a party? So instead of sending them through the regular speed post and them having a quote amin going and trying to serve it, you can have it served through WhatsApp. You can serve it through SMS, email, etc. Enforceability of it, it depends on which kind of dispute resolution you're using, but it's possible to use technology for service. You can upload documents on a platform, you can execute awards, you can digitally sign documents, you can conduct hearings on a virtual hearing. All of those things are ODR. That can be possible for negotiation, for mediation, for conciliation, arbitration, litigation, everything. So ODR is not another beast in the spectrum. It sits on top of it. Next, I think the question is on, okay, during pandemic and before that, ODR, online dispute resolution, was and is emerging as a new field for ADR. What is your take on it? What is its effect on privacy? And sir, what's your career advice for a law student to go for arbitration of a 5-year course? There are 4 completely different questions there. I'll take a minute to try and see what I can answer. I've already answered ODR. What is its effect on privacy? Obviously, the effect on privacy is significant because you are taking a lot of that information, maintaining it on a digital environment. Now, it's not more information than you would take in a real world. Because even in court litigation, you submit a lot of it. Whenever you file an affidavit, for instance, you will say what your name is, what your father's name is, what your address is, what your age is. So a lot of your personal information is already taken in even in a litigation setup. But the point is, it's not easily accessible. Whereas once it goes to a digital world, it's more susceptible to attack. It's more susceptible to intrusions by hackers or even misuse by the online dispute resolution providers. There might be a lot of data analytics that can be done on it. So privacy concerns are heightened in an ODR mechanism, but that's something that you need to factor in. And there again, you look at the transaction costs. The cost of going to court, waiting there an entire day, matter not reaching, maybe you have 20, 30, 40 hearings for one particular matter versus doing it in an online mechanism where there's more predictable time slots when the matter reaches, where you can argue a matter. Transaction costs are reduced. So it becomes a balance. You balance some privacy concerns with transaction costs. And in that balance, you don't give up privacy. You take measures to ensure that the data is private. So you use secure servers, you ensure that data is encrypted. So you make a little bit more effort to choose the service provider so that those concerns are not done away with. What is the career advice for a law student to go for arbitration after a 5-year course plan? I'd say arbitration is litigation at the end of the day. It's trial. It's not in court, but it's still trial. It's still civil advocacy. You still have to do written pleadings. You still have to do witness examination, cross-examination. Ultimately, you have to argue the matter orally. All of which is exactly how it happens in courts, but maybe in a more refined fashion. So I would say anything that gives you trial experience, which is you go to court and argue an original suit, not an appellate suit, where it is only at the stage of arguments, not writ petitions, but original suit in a civil commercial nature. If you can get some experience in that for the first few years, that will set you on a good path for arbitration. You don't have to start arbitration from day one, but start with some trial advocacy. Okay, next. Acknowledging that there is a huge range of literature and mechanisms of dispute resolution, do you think there is still any scope or issue that requires or may require academic research? There is a lot of potential, and unfortunately, because of time, I wasn't able to cover it, of overlapping and intersecting dispute resolution mechanisms. So, for instance, you can have a mixture of two. Sometimes they call it, an example I can give you is ARB-MED or MED-ARB, ARB-MED-ARB, where you start with arbitration, you go to mediation, you come back to arbitration. So you don't have to stick to one. You can pick and choose which one, and you can go in a particular order. there's a number of challenges with choosing different dispute resolution mechanisms, because confidentiality, privacy. In mediation, for instance, a lot of data is confidential. Like, even if I tell the mediator something in confidence, that whatever I told the mediator can never be used in court. Whereas in an arbitration, if I'm delivering it to the arbitrator, it is meant to be used for the purpose of resolving the dispute. So there are complications of mixing different things. So there's a lot of literature on that also, and there's a lot of scope for research on that. I'm happy to take some questions offline to see if there is any specific areas you want to focus on, and give you some tips on it. Does enforceability of an arbitration award have something to do with institutionalized tribunal? Now, I didn't go into very much detail of arbitration because I know Arush is going to do it, but a quick one-line thing. Enforceability and institutionalization have nothing to do with each other. Every arbitration award is enforceable under the Arbitration Conciliation Act. Under the New York Convention, arbitration awards are enforceable. Whether it's institutional arbitration or ad hoc arbitration is irrelevant. And Arush, I'm sure, will deal a little bit more on exactly what is ad hoc arbitration, exactly what is institutional arbitration. In the 45 minutes, it's too little time for me to go into some of those elements. Just one more thing I wanted to deal with, pending any questions coming in, is the kind of future you can have as in ADR. There's a number of career streams. You can be counsel, where you're advocating the party's interest in a negotiation or a mediation or an arbitration. You can be counsel. And another element that people often overlook is you can be the neutral. You can be the mediator. You can be the arbitrator. You can be the conciliator. And there's great scope for it. As of now, it's usually only the retired, district, high court, Supreme Court judges who are playing this role. But that what that has meant is it's clogged up the system. ADR was supposed to be, we were saying litigation. There are so many court cases pending in court that you can't go to court and get speedy resolution. So let's do alternative dispute resolution. But now, even in alternate dispute resolution, you have the same bottleneck of the neutrals being the same people who retire out of the system. So there's only so many of them. Unfortunately, the disputes are not only so many of them. The disputes are in the millions. So there's great potential for a lot of people to be neutrals. There's a skill set that you need to acquire for that, but there's a huge potential for it, especially as part of ODR. I'll give you an example of when in our center, when we're doing a lot of work, we routinely encounter cases, institutions which have somewhere in the region of 600 to 1,000 cases every month. Imagine the need for dispute resolution professionals for that huge volume of cases. They're all very simple. So you don't need someone with great international experience to try and resolve them. But there is a great demand for it. Equally, those are not the kind of disputes which will pay you in lakhs or crores of rupees, which a number of arbitration practitioners are now used to. They will pay you in the hundreds or thousands, but volumes makes up for it. So it's very important to you, especially as younger arbitration practitioners, as students, to consciously keep an eye out on ODR and this neutrals, because there's great potential and there's a great demand in the market for people who are trained, especially with vernacular languages. The advantage of an arbitration is also the procedural flexibility. So I can talk to a person in Hindi, I can talk to a person in Gujarati, in Marwadi, whatever is amenable. So if you have skill sets which are language based, you can truly use ADR to its full potential. We don't have to make ADR Victorian English language. We don't have to make it English language. We don't have to make it, notarized, stamp paper, affidavit. You don't have to do any of that. You can do a lot without being bogged down by the Code of Civil Procedure and the Evidence Act. So the world is out there for you to explore in the world of ADR. So please keep an active eye on being neutral. So if you want to explore that a little bit more, please reach out to me. As part of CORD, I can put you in touch with the team who are actively on the lookout for case managers, for neutrals who can help resolve these disputes. And that will be a huge service, not only to the country, but also to yourself, because you will actively be involved in the dispute resolution process. Okay, barring any further questions, I know I'm about 4 minutes beyond time, assuming we started about 10 minutes late, so I'll stop there.
That's absolutely fine, sir. It was a very insightful session. And before we move further, I would like to welcome Arush, sir. We are really excited to hear you as well, sir. And
Thank you,
apart
thank
from-
you, Chaitanya. Thank you, Chaitanya. It's a hard task to follow what my dear friend has just so lucidly explained, but I shall try my best to do so. But yeah. Hi, Vikas.
Hi, Arush.
Hope all's well.
All well, thank you.
Very well, very well. So Chaitanya, you can let me know whenever I am to kick off. I'd be happy to do
absolutely,
so.
sir. Thank you so much, sir, for your precious time and willingness to contribute. We are really glad that we could have you with us. It was really an amazing session, and I express my gratitude on behalf of our organizing committee, entire law department of GCRC University, Amicus Curiae, and all the faculties of law to take this opportunity to thank you to giving your valuable insight. It was really an insightful session, as I said, and we are really grateful for such an enlightenment in this session. Now, I request Dr. Namita Jain, our HOD, to felicitate the guest speaker with the e-memento.
Thank you. Thank you very much, ma'am.
Thank you so much, sir.
All right.
Thank you so much, sir. Now I would request Kajal, the moderator for the next session, to please continue.
Yes, sir.
Over to you, Kajal.
Hi, Arush.
Hello, how are you?
I'm good.
All's well.
Yeah, all well.
Good to see everybody.
We missed you at the inaugural session.
I was there. I was in
there?
hibernation mode. Yeah, of course I was there. Of course. My camera
then,
was off.
Then definitely we missed you. Missed to address you.
No, not at all. I was in fact. I saw all of it. I wasn't able to open my camera because I was having a late Saturday breakfast, so I didn't want to be seen on camera.
Okay.
Good afternoon, everyone. I, Kajal Parekh, student of third year, will be hosting this part of the session. And to continue the strings of these wonderful sessions, now we'll be moving forward with the next part of the session. And this part will be focusing upon the concepts of arbitration in India and the laws related to domestic arbitration and its procedure. And for this session, I would like to welcome Mr. Arush Khanna. Welcome, sir. Mr. Arush Khanna is an advocate and legal consultant enrolled with the Bar Council of Delhi. He started his practice in 2012 after graduating from the Symbiosis Law School, Pune, and has also done his master's in business law from the National Law School of India University, Bangalore. He is the fifth generation lawyer in a family of highly respected lawyers. After having worked with Messrs. Karanchiwala and Company and the chambers of Mr. Sanjeev Anand, advocate at Delhi High Court, Sir has started his independent counsel and advisory practice in New Delhi before co-founding Newman Law Offices. Sir has specialization in commercial disputes with a key focus on arbitration, IBC, and antitrust. The list of clients he currently represents and advises includes Fortune 100 companies such as Lenovo Group and Motorola, and other major companies such as Corning Inc., Ansel API, Asian Hotels, Hyatt Regency, and TGI Fridays, etc. Some noteworthy accomplishments of Sir includes appointment as India's national representative at the Young Committee of the International Bar Association, appointment as an officer of the Young Lawyers Committee at the International Bar Association. Also, he named as one of the India's future legal leaders by the India Business Law Journal and included in the coveted ALB's India's Rising Star 2021. And so much more now, as we all are waiting for Sir so that he could enlighten us with his kind words. Over to you, sir.
Thank you, Kajal, for your. Am I audible to everybody?
Yes, sir, you are audible.
Great. Thank you so much, Kajal, for this very, very generous introduction of yours. I'm not used to it. I get a little embarrassed, but thank you. Thank you so much for your most charitable and generous introduction. Well, greetings of the day to everybody. I hope all of you and your families are keeping in good health. I just saw the participation score at the bottom of my screen. It's endearing to see such a great level of participation from students, practitioners, and academicians, especially on a Saturday afternoon, for this very well curated and organized national boot camp on performance and practice of arbitration, organized by the JECRC University. If the grand inaugural and the opening talk by my predecessor, friend, and colleague is anything to go by, then I'm sure everybody is in for an intellectual fest over the weekend. So, friends and students, as Kajal has already introduced me, but I'll still give a shorter introduction to myself. My name is Arush Khanna. I'm a partner with Newman Law Offices, a boutique law firm having 2 offices. I head the firm's commercial laws practice, which has a key focus on arbitration and IBC. Today, as I've been asked to, I will endeavor to speak on 2 broad issues within the contours of arbitration in India. Number 1, arbitration as an emerging concept in India. Number 2, the procedural law in the Indian seat, which is essentially part 1 of the Arbitration and Conciliation Act of 1996. I would request my colleague, who I believe has co-hosting rights, to please share her screen. We have prepared a few slides for, for the ease of reference of so many of our students over here. Just a minute, 1 second. Can everybody, Kajal, can you confirm that everybody has access and can view the slides?
Yes, sir, I can. Yes, sir, everyone has the access to the slide.
Perfect. So I would now start with the first module of my talk today, which is arbitration as an emerging concept in India. If my colleague could switch the slide, the evolution of arbitration laws in India, not the arbitration, but arbitration laws in India, can be compartmentalized into 3 broad phases. The first one, the pre-1940 phase. There was an era of scattered laws. Phase number 2, the phase between 1940 to 1996, where we had the Arbitration Act of 1940. And the third phase, which is the current phase, is the phase post 1996 Arbitration and Conciliation Act, along with some noteworthy amendments. I believe there are 3 noteworthy amendments, which I'll be speaking about. When we come to the first phase, the first enactment that was devoted solely to arbitration in India, or a part of India at the time, was the Indian Arbitration Act. It was a pre-independence colonial law, and as was the case with most progressive colonial laws, they were only limited to the presidency towns of Calcutta, Madras, and Bombay. Come to phase 2, the Arbitration Act 1940 was essentially a ripoff of the English Arbitration Act of 1934 and was a complete code for domestic arbitration. It did not contain any provision for the enforcement of foreign awards, for which India had to pass a separate legislation 21 years later called the Foreign Awards Recognition and Enforcement Act of 1961. There were some shortcomings in the 1940 Act. The Act provided, it had gaping loopholes, which then led to extensive court interference. There was no provision for conciliation and other means of ADR. The Act, most importantly, I think the biggest fallacy in that legislation was that it did not recognize an award as a decree of the court. An award passed under the old Act had to be, you had to make an application. The award holder would have to apply to the court to first make it into a decree, which would then need to be enforced, adding another layer to the cumbersome procedure of enforcement during the day. Cut to the third phase, which is the current arbitration law in India, which is the Arbitration and Conciliation Act, which is, as most of you know, based on the UNCITRAL model law of international arbitration and UNCITRAL conciliation rules of 1980. It deals with domestic arbitration, it deals with international arbitration, it provides for enforcement of foreign awards, and it has a dedicated chapter or a dedicated portion of the Act, Part 3, which is dedicated to conciliation. With that, I would move on to the next broad topic, which is the procedural law of the Indian seat. Effectively, a brief overview of the procedure for the conduct of an Indian seated arbitration, i.e. a domestic arbitration. As you can see, my colleague has very, graphically or in a good tabular manner tried to explain the process for the ease of reference. I'll just briefly go through these, then I will go through each point in a illustrative and elementary manner, or I will at least endeavor to do so. The motherboard of an arbitration is an arbitration agreement, which is then followed by the arbitration notice, which leads to the procedure for appointment of arbitrators. Most of you might be knowing the provision for interim reliefs that can be sought for before the court as well as before the arbitrator. We then come to the arbitrator's power to rule on its own powers under the doctrine of competence. I'm sure some of the arbitration aspiring students would have heard of this doctrine. I will touch upon it. Then we come to, of course, conduct of an arbitration, the proceedings, the hearings that have to be taken place, which is followed by, of course, which leads to the arbitral award. The arbitral award is, of course, not appealable, but it is correctable under Section 33 of the Arbitration Act. Again, I will be deep diving into that in my later slides, which is then followed by recourse or a challenge or objections to an arbitration award. Since there is no appeal, there are limited grounds under which we can seek to challenge the award, which is followed by the procedure for appeal or the right to appeal that one has under the Arbitration Act. And of course, lastly, I'll be speaking about enforcement. So I think we can start off with stage number one. As I had told you, that an arbitration agreement is essentially the motherboard of an arbitration. It is the genesis from which an arbitration germinates. There's certain essentials that one must keep in mind and certain criteria that has to be fulfilled for an agreement to be a valid arbitration agreement. First and foremost, it has an existence which is independent to that of the main contract. I'm not reading the meaning of it. I'm sure everybody has access to the screen, so you can read it. I'll tell you something which is a little beyond what the slides also say. Firstly, as I said, the independent existence of an arbitration agreement, which means that if your main contract is null and void or voidable, that does not ipso facto render your arbitration agreement as void or voidable. An arbitration agreement is an agreement that must be in writing. Having said that, it need not be signed by the parties. The traditional notion that an agreement or a contract must be signed by both the parties is a notion which is not there for an arbitration agreement. Even an email exchange or exchange of any communication specifying, quote unquote, the intentions of the party to refer the dispute to arbitration has to be discernible. If by exchange of two emails, the intention of the parties can be gathered that they want to arbitrate, that constitutes a valid arbitration agreement. You do not need a traditional contract form of an agreement to have a valid arbitration agreement. I'll move on to stage two, which is the arbitration notice. After the arbitration agreement, there is a contract, which of course forms the basis of the arbitration agreement. And any aggrieved party, in order to commence arbitration, needs to invoke arbitration. And a well-drafted arbitration notice must contain a gist of the entire matter, the claims you want to claim from the other party, and must draw reference to the arbitration clause under which you are sending the arbitration notice. So the arbitration notice has to derive its strength from the arbitration clause or the arbitration agreement, which you have to refer to in your arbitration notice. And what is traditionally practiced is, if let's say the arbitration clause has a provision for appointment of a sole arbitrator with the mutual consent of both the parties, then the aggrieved party normally proposes a name of the arbitrator in the arbitration notice. So the claim is specified, you draw reference to the arbitration clause, and then you even appoint a proposed arbitrator. and the other party, it is upon the other party. You call upon the other party to either accept the appointment or to suggest another name, which is, there is normally no consensus as an item between the parties. So inevitably the parties end up going to court, which brings me to stage 3, which is appointment of arbitrators. As you can see, stage 3, the parties are free to agree on a procedure for appointing the arbitrators. Failing any agreement in an arbitration with 3 arbitrators, each party shall appoint 1 arbitrator, and the 2 arbitrators shall appoint the 3rd arbitrator. If in case of a sole arbitrator appointment, the parties are unable to agree within a period of 30 days from the date of the arbitration notice or the date of the intention to appoint the arbitrator by one party, then they must move the court under Section 11 of the Arbitration and Conciliation Act to secure the appointment of an arbitrator. So 30 days is the time given under the Act for both the parties to agree on an appointment, failing which they can go to court and seek their appointment. And just as an additional knowledge, if you are in an international commercial arbitration, you do not have to move the high courts or the principal civil court. You move an application for appointment directly to the Supreme Court, unlike the case in domestic arbitration. Now, post the 2015 amendment, I'll just come on the interim reliefs as well. Just post the 2015 amendment, there is a mandate on a court hearing an application for appointment that it has to dispose of the application within 2 months. And the court, while hearing a dispute, or rather hearing an application for appointment of arbitrator, has to confine its powers to only seeing if the arbitration agreement is valid or not. It cannot go into the merits of the dispute. That will have to be gone by the arbitrator. They will not see whose claim is maintainable, reliefs can be granted or not. They're not going to look at it. They're only going to see whether the arbitration agreement is valid. Now we come to interim measures. As my predecessor, friend and colleague just touched upon, during the course of any civil or commercial proceeding, there are occasions where parties seek urgent and interim reliefs. They could be in a form of a status quo on the assets if you are apprehending that the other party might siphon off their assets. They could be an issue regarding stay of bank guarantee, where you know that the bank guarantee is about to expire, the other party might encash the bank guarantee. There could be an issue on that. So the arbitration law provides for 2 modes of interim reliefs. Under Section 9, you move the court either before the arbitration, during the arbitration, or any time after making the award, but before the award is enforced. A party may apply for interim measures of protection so that the subject matter of the arbitration is safeguarded. If you don't get that stay on a bank guarantee, which in reality is very difficult, but if you don't get it, then your arbitration is nugatory. It's of no use. It's infructuous, as they call it in legal parlance. So sometimes to safeguard the subject matter, the property, what if it's a case for immovable property? I need to make an application for an interim relief to the other party to say, listen, you direct the respondent not to create any third party right. Otherwise, it's of no use because I'm suing you for recovery of my immovable property. I'm just giving you a hypothetical example and a rather elementary one. And these provisions of interim reliefs, of course, I told you about the interim relief that can be granted by a court. Similar powers are vested with the arbitral tribunal, but only during the arbitration procedure. So if it's before, during, or after, you can move the court. If it's during, you move the arbitral tribunal. Now, what does the 2015 amendment says? That you will not move an application for interim reliefs during an arbitration before the court. You have to move it before the arbitral tribunal unless you are of the opinion that the arbitrator cannot grant an efficacious remedy to you. So the intent being, you should now move the arbitrator for interim reliefs as opposed to adding to court interference and having the courts to intervene. That is the encouragement. And there's one more very noteworthy amendment that came about in 2015. That once the party obtains interim relief, it has to invoke arbitration within 90 days. It used to happen very often, and I say this with personal experience, that parties would get an interim stay, get a status quo on the asset, and then sleep over it. There will not be any urgency to invoke arbitration. We have the stay. He's not going to part with his. There's a stay on my bank guarantee. There's a status quo on assets. His assets are attached, or whatever it is. I don't need to commence arbitration. I'll put pressure on him. He'll come on the table. This practice has been dispensed with. 90 days, you invoke arbitration. Otherwise, the order lapses. I will come to the stage of preliminary objections. We come to the stage, the doctrine of competence, which I am sure some of the arbitration students who have done arbitration would have seen. Now, the arbitrator has the power and the competence to rule on its own jurisdiction. This includes opining or declaring or passing an order in relation to the existence and validity of an arbitration agreement. So in case the claimant has invoked arbitration, the arbitrator has been appointed. What if the respondent is of the opinion that I never signed the agreement, or that this matter is a matter which is not arbitrable, or that the arbitration agreement is invalid? He need not wait for the entire arbitration, the pleadings, the evidence, framing of issues, everything to happen, and then raise this plea at the time of final arguments. He can raise this plea on or before his filing of statement of defense or a reply or a written statement. A written statement is normally used in suit parlance, not in arbitration, but he needs to move this application on or prior to his pleading, which is his reply to the statement of claim, and he can object to the maintainability of the proceeding, and the arbitrator under section 16 of the Act has to rule or pass an order on that preliminary objection. So for any arbitration which the other party feels is not maintainable, it need not go through the entire ordeal of the arbitration, files a preliminary objection application. Under this provision, the arbitrator can rule on it. And that is why a court, when it looks at an application under Section 11 for arbitrator appointment, it does not see the merits of the matter, because you can raise this plea before the arbitral tribunal. Now we come to stage 6, which is conduct of the arbitration proceeding. This is divided. I've tried to compartmentalize it into 4 main headings. Of course, there's no, I would strongly recommend all students to have a look at sections 23 to say 29 for this, for a better explanation of the stage. But I, for the ease of reference, I've compartmentalized it into 4 stages. First being the case management hearing. Ordinarily, the first meeting in an arbitration is called the case management conference, or the first procedural hearing. It could be used, different terms are used in ad hoc institution arbitration. In the case management, the parties convene to decide on a timeline or a schedule for a filing of pleadings. It might say, okay, claimant will file its statement of claim in 3 weeks, followed by the respondent filing its reply in 3 weeks, after which the parties will, there's another thing, the mode and manner of the arbitrator's fee has to be decided at the case management hearing. You decide a timeline of the arbitration, that X will happen at X time, this is framing of issue, this is evidence, this is final hearing. A schedule is laid down. The arbitrator's fee is decided. The arbitrator makes a disclosure that it is not conflicted. It has no relation with either parties or counsel or the subject matter which is before the arbitrator. This is a new feather in the arbitration law of India, where the arbitrator has to make a disclosure under section 12, taking reference to schedules 5 and schedule 7 of the Arbitration Act, and say that I am independent and I have the time and my schedule permits me to conduct this arbitration in accordance with the Act. After the case management hearing, of course, the parties file their pleadings, and normally in any progressive arbitration, there is no meeting required for filing pleadings. You will exchange your pleadings over emails or physical filings. If they're still there, they can courier it to the arbitrator and it constitutes a valid filing. One does not need to convene a physical congregation or even a virtual hearing for that matter. Ordinarily, it is only at the stage of framing of issues that the parties convene again. Now, what is an issue? I urge all students to look at Order 14 of the CPC. When a material fact is alleged by one party and denied by the other, that is a material issue that has to be proved. It has to be proved at the stage of trial. So ordinarily what happens is The arbitrator would direct the parties to submit their proposed draft issues. The parties meet. There are certain, certain issues that have to be greased, and normally a physical or a virtual congregation of the parties is deemed necessary and appropriate for framing of issues, because it might involve parties to intervene at certain occasion. So once the issues are framed, there are three kinds of issues. One is the issue of fact. One is issue of fact and law. The other is issue of law. Now, if it's an issue of fact, or if it's an issue of fact and law, it requires the party to lead evidence. Legal issues don't need evidence that you can argue at the final argument. But then we come to the third stage, where the parties have to lead evidence. Now, how do the parties lead evidence? In modern day arbitration, there very rarely are there examinations in chief. The parties file their affidavits in lieu of examination in chief, which is a written affidavit, and the other side has the liberty to cross-examine if they deem it necessary. Otherwise, sometimes, on most occasions where their electronic records are exchanged, sometimes one doesn't even need oral evidence or cross-examination. One can just file an affidavit, and that's good enough. So that happens. The stage of evidence happens when the party who's filed the affidavit is then cross-examined by the other side. It will happen for the claimant first, when the respondent will cross-examine the claimant, and then vice versa. This is the stage of evidence. This is the broad stage 3. After framing of issues, after evidence, we come to the final hearing, where, of course, the arbitrator has to decide on the issues framed basis the evidence that has been led by the parties to prove those issues. Every issue has an onus. The issue might have an onus if, let's say, the claimant has alleged that there has been a breach of contract by the respondent. The onus to prove the breach is on the claimant. There's a very famous, phrase that he who alleges must prove. So he has to discharge that onus during evidence, and this all culminates in the final hearing, which is, again, it can either be a virtual hearing or it can be a physical hearing, or if it's a documents only arbitration, like my colleague had just said in the earlier panel, it need not even be an oral hearing. But even written arguments are very, very well accepted nowadays, which parties at times file before they have their oral hearing, or even during their oral hearing, sometimes even after the oral final hearing. So this, friends, was a broad compartmentalization on how the arbitration takes place. Case management hearing, exchange of pleadings. After the case, then parties convene for framing of issues. Issues are exchanged. Evidence is conducted, which is followed by a final hearing. Now, all this has to happen. I'll come to stage 7 now. Under the new amendment, or rather the 2015 amendment, which was further modified in 2019, an arbitrator must make the award. There's a timeline for an arbitration, unlike before 2015, where the arbitrator was not bound to decide the issue in any particular length of time. But now he has to do so within a period of 12 months from the date of completion of pleadings. Under 29 capital A, this is the new amendment. It was initially introduced in 2015, where it was that an arbitrator has to conclude it within 12 months from the date the arbitrator enters upon reference. Now that has been stretched to completion of pleadings. It also has the amended law also has a provision for fast track arbitration, which is 29 capital B of the Arbitration Act, which provides that an arbitrator must pass an award within 6 months from the date he receives the notice of appointment. Of course, an arbitrator has to be paid a higher fee for that. It can only be done by a sole arbitrator. Oral hearings are not required for this fast track procedure that has been incorporated into the Indian arbitration regime. Now, this is, of course, the timeline the arbitrator has to make an award. Now we come to stage 8, the award itself, the form and the contents of the award. One of the quintessential requirements of a valid arbitration award is that it has to be made in writing. It has to be signed by all the members of the arbitral tribunal. If there is one, so be it. It can be one. It must state the date and place of arbitration as well as the date of the award. Under the new regime, an arbitrator has robust powers to award interest under 31 of the Arbitration Act, and under 31A, there is a strict regime for costs. If you are filing a civil suit, you are still bound by the CPC, which I think has about 3,500 rupees that are considered to be reasonable cost under Section 35 of the CPC. An arbitration proceeding has done away with that rule. You can award actual costs in favor of the winning party. Actual cost would mean legal costs, costs for pursuing the remedy. If it's a frivolous case that's been instituted by the claimant with no hope, then even exemplary costs over and above what can be justified. So, and yes, it also provides, this is something not in the Act, but I say this with personal experience, an arbitral award must incorporate within it the provision for stamping the arbitral award. An arbitral award is an instrument which is chargeable with stamp duty. Without payment of stamp duty, the award cannot be enforced. So a good arbitration award must say that this is the stamp duty, the claimant is bound to pay, or the losing party respondent will pay, or both the parties will pay. That is up to the arbitrator, but it must provide for it. Now, what happens once you have a valid, or at least on the face of it, an award in front of you? There are some recourses you can take against the award. Many a times in several complex commercial arbitration, there might be some clerical typographical errors. Any party may approach the court within 30 days from the receipt of the award and seek to correct any of these computation, clerical, typographical errors, or if they want the tribunal to give an interpretation on any specific part or point of the award, that can also be done so within the contours of Section 33. Now we come to stage 10, which is recourse, or rather challenge to an arbitral award. I had told you earlier that there is no appeal. Unlike a civil suit, there is no provision for a regular first appeal, which is there in a civil suit. An arbitration award under Section 34 can be set aside on I've just broadly explained for ease of reference. This is not bare act language. In 6 major compartments. The first ground under which you can challenge the award is that the party was under some incapacity. Number 2, the arbitration agreement was invalid. If you have raised that objection of invalid agreement before the arbitrator under Section 16 and he does not give you a favorable outcome to that objection, you can raise it again during final arguments before the court. But if you do not raise it as a preliminary objection before the arbitration, it is very difficult for you to raise it now before the court, because the Arbitration Act under Section 4 has provides that there is a waiver of right to object. If you have the entitlement and the right to object at a particular stage of the arbitration and you forego that right, or you are sleeping over that right, then you are precluded from exercising that right later. It's a concept of waiver. It originally started off as a common law doctrine, but it's been incorporated under the Arbitration Act. Number 3, the dispute is beyond the scope of arbitration. My colleague before me who spoke before me said that certain issues are not arbitrable. Probate matters for enforcement, or rather to prove the validity of a will, are not arbitrable. Tax issues are not arbitrable. Quasi-criminal issues are also debatably not arbitrable. You should see this judgment, famous judgment is called Booz versus Hamilton. My recollection fails me on the year it was passed, but Booz versus Hamilton is still the gold standard when it comes to the arbitrability of a dispute. Number 4, the arbitral procedure was not in accordance with the agreement of the parties. Very often an arbitration clause provides for a certain procedure that has to be followed by an arbitration or during an arbitration. If that's not followed, that is a ground you can take to set aside an award. Now we come to 2 of the substantive and the most popularly invoked grounds. These are more, the first 4 were more procedural. The last 2 are if the award is vitiated by patent illegality on the face of the award. This is only there for domestic arbitration. This ground is not there for international arbitration. The last one being the award is in conflict with the public policy of India. Now, patent illegality, I must say, does not mean any mere violation of the law need not, or wrong application of the law on the facts of the case need not necessarily be a patent illegality. The court is not going to sit inside the mind of the arbitrator and going to say, okay, he's appreciated the facts in this manner and applied the law in this way. That is the autonomy of the arbitrator. If it's so glaringly perverse that it shocks the conscience of the judicial mind and the judicial court, then only the arbitrator is going to intervene. And I will come to a judgment that is a classic explanation of this concept later on. But this is the concept of patent illegality. It need not be a mere infirmity in the law. It has to be glaring error on the face of the record. Perverse. No judicial mind can come to that conclusion. And of course, the widest ambit under the arbitration law is that it is in conflict with the public policy of India. Just before we get, I'll just brief upon the concept of public policy of India through the story of some cases. But I must tell you, very important, that the laws of limitation when it comes to an arbitration are supremely strict. And a party within 3 months has to move the court for a challenge. It only has a period of 3 months from the date it receives the award to file a challenge under Section 34. This period is extendable with sufficient reasons for a further period of 30 days. Now, many people say that, we are 90 days and 120 days. No, it's not 90 days, it's 3 months. There's a judgment to that effect also. Do not equate 3 months with 90 days. It need not mean 90 days. But 30 days is also not equal to a month. So the time period is 3 months, extendable for a period of 30 days. It does not mean it's 120 days. So that is something that a lot of people err in, and it's actually costed a lot of parties, because even if there's 1 day of delay, then you could actually lose out on the challenge just on the short point of limitation without going into the award. We'll come to, I'll just, as I told you, one of the most widely spoken grounds is the ground of public policy, which has also seen a great evolution right from the time of the great Renu Sagar judgment of 1994, which is of course under the old act. It defined public policy as the fundamental policy of Indian law if it was in violation of the interest of India or justice or morality. You can see the screen. I'm just going a little fast. I don't want to be beyond time. Then, of course, we come to the infamous case of ONGC versus Saw Pipes in 2003, which applied the concept of patent illegality to foreign awards, which was sought to be enforced. This had to be corrected in the 2015 amendment. And most recently, I was talking about a classic case of the concept of patent illegality is the case of DDA versus Associate Construction. This is Associate Builders versus DDA, 2015. Rohinton Nariman has passed that judgment, and this is really now one of the best references for any student to understand what is the scope and ambit of public policy in India and patent illegality. So I'd strongly recommend, and of course, a latest judgment over here is also Sanyong Engineering versus National Highway Authority in India, which in effect overruled the judgment passed in Western GECO, GECO meaning GECO 2015 judgment, again of the top court, which explained the concept of patent illegality. So now, to understand the concept of patent illegality, I would recommend students read the judgment in the Sanyong Engineering case, which is 2019. It's the latest and probably the most referred to when it comes to patent illegality. So I'm not deep diving into the facts, merits, and ratio of these cases because that will take a lot of time. But I guess everybody's got a gist of them. I'll come to the stage of appeal now. Now, the Arbitration Act provides for 2 modes of appeal, essentially 2 broad modes. One is appeal against the orders of the court passed under sections 8, 9, and 34. 9 I already told you, 34 I've already told you. 8 is when a party makes an application to the court saying that when one party has an arbitration agreement with the other party and it still goes to the court and files a civil suit, then the other party comes up under section 8 and says, no, there is an arbitration agreement, refer the parties to an arbitration. This order of the court is appealable. An order passed for interim reliefs is appealable. An order passed under section 34 is appealable. The arbitration award is not appealable, but the order passed under section 34, which is challenge to an award, is appealable. Again, in 37 clause 2, we have for, or the Arbitration Act rather, has provided for an appeal directly against an order of the tribunal. As I said, the arbitral tribunal can hear preliminary objections under the doctrine of competence. But what if the parties agree with the order? It can move the court in an appeal. Only if that plea is accepted. If the preliminary objections are rejected, then the party can only go after the award has been passed. So there's a thin line. If the objection is accepted, then of course the arbitration basically lapses, it abates, it ceases to exist, and therefore the parties have to go and appeal. But if the arbitration continues, then you can only challenge it at the stage of section 34. As I said, interim reliefs can be granted by an arbitral tribunal if a party is agreed with the order of the interim relief, which has been granted, or rejected. They can go to the court in an appeal. We can now move on to the stage of enforcement, which has seen some noteworthy amendments. So an arbitral award under the 1996 Act is akin to a decree of the court. And just like any other decree passed in a civil suit, it's enforceable as a decree of the court. So the principles under Order 21 of the rule CPC, or rather Order 21 of the CPC, apply to enforcement even of an arbitral award. Now, before the 2015 amendment, what used to happen is the party would challenge the award under 34 of the Act. The court would issue notice that would amount to an automatic stay of the award. This practice has been done away with the 2015 amendment, where the party who's challenging the award has to file a separate stay application and satisfy the court that the award should be stayed. And the court has to apply the principles under Order 41, Rule 5 of the CPC, wherein if the award provides for payment of money, normally an award would amount some obligation or some payment from the losing party to the award holder. It has to deposit that amount in court as a precondition for stay. So it's not only that I have to apply separately for a stay, I might have to pay money to the court. The money that I have to pay to the award holder, the court will say, okay, deposit the money in court, we'll stay the award. This practice was slightly deviated from in the latest 2021 amendment, which was introduced by way of ordinance, is that if the arbitration agreement or the award is induced with fraud or corruption, then you can even get a unconditional stay of the award. You need not deposit money to get a stay of the award, but you have to then satisfy to the court that this award is induced by fraud or corruption. And this ordinarily should happen if you have already pleaded it before the arbitration, but that's a practical insight. I won't get very deep into that. Now I will come to the table of amendments. That would probably be my last effective slides. I've already spoken about some of the amendments, but I've just sort of tabularly tried to show you, students can see this table and, draw some reference from it. I think we spoke about interim reliefs. I spoke about independence and neutrality and how the arbitrator has to make a disclosure on affidavit or even in a part of a case management order. The timelines have been introduced in the 2015 amendment. Very interestingly, I'll just touch upon one topic that is really interesting, is the introduction of section 87 under the 2019 amendment. So what happened after the 2015 amendment was that it had to apply, like most amendments do, unless specified otherwise, have to be applied prospectively. So the amendment was introduced on October 23rd, 2015 by an ordinance. So the amendment says that it will only apply to arbitrations which have been commenced on or after 23rd October 2015. This was clarified by the classic case of BCCI versus Kochi cricket. I think it was a 2015 case, which said that, okay, it applies to all arbitration that commenced on or after 2015, October 23rd, But if a court proceeding has commenced on or after, like a section 34, or an appeal has commenced after 23rd of October 2015, then also the amendments will apply even if the arbitration started before the amendment. So it was a progressive and interpretation of the amendment, saying that otherwise there is no use. Even if the court proceedings, I'll repeat, arising out of the arbitration commenced after the amendment, then the amendment will apply even if the arbitration started before the amendment. Now, what happened in the 2019 amendment was 87 was introduced, which completely rendered this case law as non-est, inapplicable. It says that 2015 amendments shall not apply to any arbitration that has commenced on or prior to 23rd of October 2015. So therefore, it was a case of one step forward, two steps back when it came to the 2019 amendment. That had to be corrected. And it was corrected in 2019 in the very, very landmark case of Hindustan Construction Company versus Union of India, where Section 87 was struck down as unconstitutional. The apex court had already passed an order clarifying the amendment. So therefore, this legislation trying to nullify the effect of a Supreme Court order wasn't taken very well by the Supreme Court, rightly so. So as things stand, BCCI versus Kochi is still good law. It's just been improvised by the Hindustan Construction Company case. I think, do we have slides on that? Maybe the students can just read it for a moment before we can get to the Q&A or feedback, whatever. Do we have any slides on that case?
No, sir, we don't have as of now.
All right, great, fantastic. But nonetheless, I'll be happy to share the citations of that, of those two cases as well. But I think with that, I think I'm already 40 minutes down, and I need to give some time for Q&A as well. So I'll be open to any comments, feedbacks, questions if anybody has. I haven't seen the chat bar, but Kajal, do we have any questions?
Yes, sir, we have questions, and
I'm not able to see. I saw.
Sir, I'll read it for you.
Mr. Shah has sent something, which of course the latest. Sir, kind request, please share the PPT as possible. By all means, I'll share it right after this presentation. I'll do that. Yes, Kajal, tell me.
Sir, the first question is the arbitration award agreement is valid even when the main contract is void?
Yes, so an arbitration agreement need not be void if the main contract is void. But what happens is an arbitration agreement in practicality does not have a standalone existence. You will still claim reliefs arising out of the contract. So it will be inoperative. It legally may still be a valid agreement, but it's of no practical use because the main contract is void. So if the main contract is a void contract, then you can probably say that yes, my arbitration agreement is valid, but can you claim any substantive relief because your main contract is void? So it's in practicality, it renders an arbitration agreement inoperable, if I can use that word, but not invalid.
Sir, the second question is how jurisdiction play its role? How jurisdiction play its role when arbitral award is challenged in court of law when the proceedings were done through ODR?
Proceedings was done through ODR, then I'm sure that even in ODR proceedings, the party who wants to object as a preliminary objection, wants to object to the maintainability of the arbitration, can file an application even on the ODR platform. And if that application is rejected, then it can raise the same point when it challenges the award in a court of law under 34 of the Act. So the ODR mechanism does not make a departure from the standard procedure that has to be followed under the Arbitration and Conciliation Act. ODR is just a procedural convenience mechanism. It by no means changes or alters the steps that a party has to take in an arbitration. So raise the preliminary objection before you file your reply as a respondent. If the court rejects it, then challenge the arbitral award on the same grounds during 34. So if that answers the question.
Okay. Yes, sir. And sir, the last question is, are the foreign award with the third party funding enforceable in India?
Yes, of course. A foreign award is very well enforceable in India. That's under Part 2 of the Arbitration Act. Any country that has signed the New York Convention can have its award enforced under Part 2, and that there are certain conditions. A party under Section 48 can resist enforcement, and patent illegality is not a ground to resist enforcement of a foreign award. But yes, a foreign award with a third party funding is very well enforceable in India, just like any other foreign award is.
Okay. And sir, there is another question as well. The latest development on unconditional stay appears to be a step backwards to the time before 2015 amendment. Even in the case of fraud, do we have an alternative for expedite proceedings apart from unconditional stay?
Okay, the unconditional stay is, yes, I think I do agree with you. I think it's a step backward. I think a lot of parties, parties who've lost in the arbitration and have a enforcement looking at them on their face might plead fraud or corruption. And even if they lose out on that plea, it will still take time for the court to decide that plea. So I think some court intervention is required in this provision per se to lay down the standards. Firstly, they have to say that if you haven't pleaded fraud or corruption before the arbitral tribunal, you are precluded from raising it as a ground for unconditional stay of the award. That concept of waiver has to be applied. Otherwise, every party belatedly would say, if the arbitration agreement was induced by fraud, the arbitration agreement was in existence from far prior to even the starting of the arbitration. So you had the time to say that, no, it's a fraudulent agreement. If the arbitral award is induced by fraud, then also at the stage of 34, you have time to say, no, the arbitral award is induced by fraud. So I think the court will have to lay down certain standards. I don't think this was necessary, although it does help me in some of my arbitrations where I'm appearing for the losing party personally. But as a student of arbitration, I do believe it's a step back. But I'm sure the courts will intervene. It's just been passed, I think, about 3 months back as an ordinance. I don't remember the exact date of the ordinance, but I think it was April or maybe end of March. So yes, if that answers your question.
The another question, sir, is what is the significance of award under Section 34 if the appeal against order can be made?
What's the significance of an award under Section 34? The significance, award is passed by the arbitrator that you challenge in 34. If the appeal against the order can be made, I am not able to exactly decipher the what response or what guidance my friend Shreya actually wants. But if she can, she can even come on the screen and share that question. But what significance? What is the significance of an award under 34 if the appeal against the order can be made? No, now I get it. So yeah, Shreya, I think Shreya has raised her hand. Let's hear from
her. Yes, sir. Actually, I'm saying that arbitral award is not appealable, but the order which the arbitration is passing is appealable. So in that order, if I'm challenging the order, then I can set aside the arbitration award as well. So what is the significance of that particular thing then left?
No, so of course there is. See, the award can be challenged, as I said, on limited grounds. And the appeal against that award, the appellate court, let's suppose, okay, I'll give you a practical example. There's an award against you. You cannot appeal against the award per se. Using the principles under Order 41, I strongly urge you, because an appeal from an order in a suit is filed under Order 41 of the CPC, under which the first appellate court is the last court of fact. It can reappreciate evidence, see the merits of the case. An arbitral award cannot do that. 34, the limited grounds, as I have explained. Now, if the parties agreed by an order of 34 The appeal can be made under 37, but the power of an appellate court under 37 of the Arbitration Act is even narrower than 34 of the Arbitration Act. So it is not like a first appeal against an order of a suit under Order 41. So to understand this question better, you need to, see the explanation under Order 41, read it alongside Section 37 of the Arbitration Act. The scope is far narrower. So by saying that just because we have an appeal against an order of 34, that does not mean it's a regular first appeal under the CPC, because the CPC, a first appellate court, has extensive power. It can even conduct a retrial of the proceeding. It's almost like another suit file. But 37 will only see the grounds on which your 34 is rejected. It is not a gateway to going into the merits of the arbitration, not for a moment. So I strongly urge you to have a look at Order 41 and Section 37. You will get an answer to this question in far greater detail. Of course, I have to keep myself short. Everybody would want to break for lunch now.
Thank you, sir, for this session. And coming to an end, I would like to request Dr. Namita Jain ma'am, HOD, Faculty of Law, to present the e-memento to our guests.
Thank you so much, sir, for such an informative session. Please accept this e-memento as a token of gratitude from Faculty of Law, JCRC University. Thank you so much, sir.
Thank you very much, ma'am. This was an absolute honor. Thank you for having me. Thank you for having me. I mean, speaking alongside such arbitration stalwarts, I was very nervous, but I hope everyone had noteworthy takeaways. If and I would also like to publicly acknowledge the effort of my team as well. I believe my colleague Ishta is also online, and she's really helped out with making the entire PPT and sharing the slides. So I'd like to acknowledge your efforts as well. Thank you so much, Kajal, Shivani, Pankaj Avasti, Mr. Shah, and everyone for having me. And thank you very much. Have a wonderful weekend and a safe and healthy year ahead to all the students. Thank you, and look forward to a continued association with your university. Thank you so much.
Thank you, sir.
Thank you, Arush.
Thank you so much.
Thank you. Thank you.
Okay. So with this, the first session of this bootcamp has come to an end, and we'll be resuming after the short break with another energetic session of the bootcamp, which is based upon the drafting of arbitral agreement, and it will be starting at 2:30 p.m. So I request you all to kindly join the session at 2:20. Thank you.
Kajal, please make announcements regarding attendance form.
Everyone has to fill the attendance form that will be provided to you by our team.
It is provided in the chat box.
And it is in the chat box. Thank you.
Okay. Thank you, everyone, for being a patient listener, and we hope to see you there back at sharp at 2:20.
Devakar, the form is only in view mode. Can I give access to them for edit?
Yes, ma'am. Just a minute. I am checking.
Yeah. Excuse me. I'll corrected the form. Now you can access the form. It's okay.
So we will put that in the WhatsApp group, which we have also. No, meanwhile have a break of lunch, and then we'll assemble at 2:20.
Sure, sir. Sure.
Thank you, everyone.
Thank you.